SJC-12247, Scott Phillips v. Equity Residential Management, L.L.C.
Mr. Garrett, good morning.
Good morning. Mr. Chief Justice, and may it please the court, my name is Joshua Garrick, and I represent Scott Phillips and a putative class of over 1,700 people that have had their security deposits wrongfully retained by Equity. The issue before this court is not whether the deposits were forfeited. They were. The issue, rather, is did Equity's failure to return these deposits within the 30-day statutory deadline result in the imposition of treble damages and attorney's fees? For over 30 years, the answer to that question has been yes. When a landlord fails to return money that belongs to a tenant at the end of that tenancy within that 30-day period, it doesn't matter how that balance is due, whether it's forfeiture, whether they made up damages, what have you. The answer has always been if that money is not given back to the tenant, that the landlord is entitled to treble damages and attorney's fees.
You're not going to be surprised, obviously, by the question, though, since 15B7 doesn't include a violation of 6B, that the damages shouldn't be trebled.
Correct. So to answer your question, indeed, it's not. Section 6B is not included in Section 7, but it does include 6E. And what happened here was a 6E violation. And the reason why it's a 6E violation is because the money at the end that belongs to the tenant, these are tenant funds, were not returned at the end of the lease.
Well, does that mean every 6B violation is a 6E violation?
No. There is a scenario in which a 6B violation is not a Section 6E violation. Consider the facts in this case. Mr. Phillips moved out at the end of May 20th. The statement of damages was provided sometime in May. So within 10 days, not the 30-day period, he was provided with that statement of damages. The statement of damages was not signed under the pains and penalties of perjury, which is Equity's obligation to do by law. Had Equity realized at that point, gee, you know what? We didn't comply with the security deposit. Had they done that and returned the funds prior to that 30-day period, there would have been a forfeiture, and if there was a subsequent action, there would have been a so, for example, if they had returned, well, in a subsequent action, they wouldn't be able to counterclaim. So there is that scenario that would exist. But I think, Justice Lloyd, the problem here is, and to focus solely on Section 6B not being in the statute, we're ignoring what actually happened. And what Equity is asking you to do is take two violations of the security deposit statute, one of which requires treble damages and attorney's fees, and they're asking for a lesser penalty. Had they done what they were supposed to, had they complied with the law and simply signed the statement under the pains and penalties of perjury.
Well, your argument would be easier if the landlord had actually refused to return the deposit within the 30 days. I mean, this is, in some respects, a technical violation,
Well,
right?
No, because they didn't return the deposit.
Well, they didn't because they claimed that they were owed money, right? Does the landlord not get to say that?
They get to say that, but here's the problem. Some of the damages that they asked for, cleaning, apartment replacement, these are things that you cannot deduct from a security deposit. You can deduct for damage, but cleaning is not a permissible deduction. Other claims, they assessed attorney's fees because there was a previous eviction action because Mr. Phillips' roommate moved out unbeknownst to our client. Equity pursued an eviction action, and part of the settlement agreement was that no attorney's fees would be paid to resolve that case. They deducted the attorney's fees. So here, this isn't just a technical requirement. And by the way, the cases addressing this particular provision, the signing the statement under pains and penalties of perjury, are very clear. This is not a technical component of the statute.
Oh,
This is
not
an
that one. I think everybody agrees that they didn't give a signed statement, but the failure to return within 30 days is a product of this violation under the failure to give a sworn statement of damages, right? It's not an independent thing that the landlord did. That's what I'm trying to understand, how you deal with that.
It is, and I think the way to conceptualize this is actually to go through the statute and understand how this works in real life, right? We're all, what happens here is a tenant gives his own money, right? Mr. Phillips was a college student. He was told by Equity that we need a security deposit, so he did. He provides the $750 security deposit. The statute is clear. This is tenant money. It's going to be held in escrow for the benefit of the tenant. It is not Equity's money. In order to deduct money at the end of the tenancy, you can, and that's addressed in subsection 4 of the statute. And subsection 4 says, the lessor shall, within 30 days, return to the tenant security deposit or balance thereof, provided, however, that the lessor may deduct from such security deposit for the following. So what the legislature has said is, this is the tenant money. Now, if the landlord wants to make a deduction, it can, and it can do it one of 3 ways. It can do it for unpaid rent, which is subsection 4.1. It could do for increase in tax, which is subsection 4.2, or it could do, applicable here, section 4.3, which is for damages. But if and only if you comply with all of these requirements, including...
I appreciate the Justice Scalia's observation about statutory interpretation in the cocktail party.
Yep.
Right. But to what effect do we give the legislature, who had all these provisions and specifically excluded this one, from the attorney's fees provision?
Because the legislature said in subsection 6E that if you don't return the deposit, that you are now covered under that section. And that's exactly what the court held in Carter, and it's what the court held in Taylor 1. And it's what is uniformly applied throughout the trenches of the housing courts and district courts and small claims courts throughout the Commonwealth. If you don't return the money, for whatever reason.
Or the balance of the money.
Or the balance thereof. And here we know that the balance is 0 because by application of subsection 6.
But let's suppose that there was $250 left. So you're saying that if they hadn't returned the $250, it would also be a violation?
So,
or if they did return the $250?
So right. So again, if the forfeiture provision is invoked here, then the tenant is owed the full deposit. So if it's $250 that's retained, or the other way around, if $250 is returned and $500 is retained, then the tenant is still entitled to that because the balance thereof, by virtue of subsection 6, is 0, or the full amount, that they're entitled to the full deposit back. So Carter and Taylor 1 are on point, and it's routinely applied, and it's important that these provisions be routinely applied because we're dealing with small money claims, typically by litigants that are pro se, and they rely on a uniform application of a statute, and that's been resolved going back to this court's decision in Miller versus Berman.
So, I mean, the essence of your claim is this is a 6E violation. It just happens to be a 6E violation, which is accompanied by a 6B violation, which triggered the 6E violation.
I think that's a fair...
You're saying the plain language of the statute is that 6E is included by failing to give a statement that's provided under the pains and penalties of perjury. The law says they have to give it all back, and they didn't.
Correct.
So, and that triggers, and that triggers 6E. So you're not arguing that we should incorporate 6B, we should read this to include 6B. You're just saying that 6B triggers a 6E violation, and that 6E is what the statute provides for.
And I think I would agree with you, Chief Justice Gantz, that that's what we're saying, that this is a 6E violation. The only reason why 6B is relevant in this situation is it tells us what that balance thereof, so to speak, is. Because the forfeiture provision of subsection 6B is invoked, we know that all 1,700 plus individuals that had their security deposits unlawfully retained, that they're entitled to the full balance. And by failing to return that, you're absolutely right, this is a 6E violation.
Can I ask you about that? If you have a 6E how else can you have a 6E violation?
Well, it could be that the landlord just makes up damages. It could be that, like equity here, that they didn't, that they deducted for cleaning charges and apartment cleaning, carpet replacement, routine
That's not, those are not 6B violations? Those are, I'm looking for some non-6B violation of 6E, just as an example.
Well, 6B goes to the itemization. 6E goes to any failure to return. So, and I think the most common way to get a 6E violation, aside from a landlord just flatly refusing to return a deposit, which happens,
Yeah.
is to say, you know, well, we think that you caused some damage. Maybe it was pre-existing damage. Maybe it wasn't. That's your typical 6E violation.
So that's without being a 6B violation, without having sent anything, without trying to comply with 6B?
Well, that's the problem, is that a lot of these provisions overlap. And in our case, we actually alleged 3 or 4 different violations of law that that equity had violated, that they didn't do the jurat, they didn't sign it under the pains and penalties of perjury, that they didn't itemize in sufficient
And
detail.
they didn't do receipts?
Well, no, that wasn't one of the allegations here. But we alleged all of this, and what happened in the federal district court is that she got to the 6B violation and said, okay, well, there was no signature under the pains and penalties of perjury. We're going to end the inquiry here because you got your security deposit back. There's no need to look at anything else. And that's not how the security deposit statute is supposed to work. If anything, it's supposed to be the inverse, that you start at the provision that has the greater penalties, and then if the district court had found that there was a 6E violation, then perhaps you could say that the 6B violation was moot.
If 6E is pretty much the catch-all, and you don't return it within 30 days, it triggers this remedy. Why would the legislature separate out A, D, and E in subsection 7?
Well, again, the legislature made abundantly clear that the utmost concern is making sure that tenant money stays with the tenant if it belongs to the tenant. So in this situation here, where equity owes this, there's no dispute, equity owes all 1,700 of these folks their security deposit back.
Right.
If by not returning that, the legislature made clear that 6E is applicable. Now, they added 6B and some other provisions. Again, going back to the answer to Justice Lowe's question, there are circumstances where these violations may be independent, and then the landlord can resolve it before he returns. This exact same thing happened in the Carra case. In Carra, the landlord was actually owed $20,000. And there was about a $5,000 security deposit that was paid, and Carra recognized, oh, shoot, we didn't comply with the security deposit. So they paid the money back.
You're
That's what a
saying, like,
prudent landlord should do.
So 6A says that you have to deposit the funds in an account. So if they took the security deposit and put it in their back pocket, you would say that's a separate violation which triggers attorney's fees,
Well,
which is independent of the 30-day violation.
right, because and again, 6A is another basis for triple damages in and of itself. But that goes back to what Justice Lenk was asking, what are situations where
Right.
what happens if the landlord just completely absconds with the money, which again happens.
Let me ask you from a little different perspective, though, because it's sometimes a little more complicated than this. When I sat in the summary process session in the Lynn District Court and the Chelsea District Court,
Sorry.
the landlords didn't have lawyers either. And what we have now is, well, under 6B, you got to give the itemization under the pains and penalties of perjury, or you can't get the security deposit back. And then under 6E, you got to return the money within 30 days. And that it is what it is. But why is it that landlord who made the mistake under 6B is facing treble damages?
Because this,
Where's the fairness in that from the landlord trying to make the mortgage on the triple decker?
because this is a strict liability statute. A landlord need not take a security deposit. If they do, all they have to do is comply with the requirements of the Security Deposit Act. These are not strenuous requirements.
I'm not saying that the landlord shouldn't have to turn the security deposit back because they made a mistake in not itemizing or not signing it under the pains and penalties of perjury. Of course they should. That's what the statute says. The issue is whether that landlord who doesn't have a 6E violation has to have the damages trebled.
Well, again, it would be a 6E violation, and that's the risk that you run when you demand security. I mean, we're certainly cognizant of a landlord that may have difficulty making ends meet. That's not the facts of the case here. We've got Equity Residential, one of the largest real estate investment trusts in the world, and if the landlord decides that to accept or to demand a tenant's money ahead of time, which is such a unique situation. You don't go into Macy's and they say, well, there's been theft, so if you want to shop here, give me $200, and then we'll give it back to you when you leave. No, this is something that a landlord decides to accept. If he does it, he knows that there's requirements. These are not owner's requirements, and if you fail to return those, if you fail to return the tenant's money within 30 days, no ifs, ands, or buts, because it's strict liability, then you have a 6E violation like you have here, and the court must award treble damages and attorney's fees.
Okay, thank you.
Thank you.
Mr. White?
Mr. Chief Justice, honorable justices, the certified question presented to this court is about whether or not every 6B violation automatically becomes a 6E violation. Our position is straightforward. To answer the certified question in the affirmative, as Mr. Phillips asked, means that you have to utterly and completely ignore Section 7 and the legislature's intent in adopting Section 7.
Well,
It's actually-
let me stop you there.
Sure.
Let's assume the legislature wanted to make a violation of B, or for that matter, C. What damages would arise from the failure to furnish the tenant the itemized list of damages?
There are none.
So, and under C, what damages would arise from a provision that conflicts with the provision of this section?
There are none.
So why should the legislature, when it's discussing trebling damages, include two provisions for which there are no damages?
First of all, Section 7 excludes B and C.
I know, but my question to you is, of course it excludes B and C. There are no damages that arise from B and C, so would they not look pretty silly to say, we're going to say you can treble a violation, a violation of B and C when you concede there are no damages from B and C? So is this simply the legislature saying we're not going to look stupid and incorporate a treble damage provision for two subsections for which there are no damages? We're only going to have trebling damages where there are damages.
An interesting hypothetical. However, I would argue that under A, it's equally likely that there would be no damages to the tenant, because A merely creates an offense for failure to deposit in a segregated escrow account. You don't have to lose the money. You can still have the money. You just fail to deposit it in the correct account. Money can be sitting right there, available to return to the tenant, but it's a violation and it's included in 7. I don't think that the legislature had the damage to the tenant in mind. I think Section 7 is about the kinds of behaviors the legislature legislature wanted to encourage in landlords when the offense involved the handling of money.
Did we have legislative history that you speak so confidently about?
No, that's why I said I think. We've looked carefully for legislative history from 1978. There simply isn't in existence anything we can find that explains why those 3 subparagraphs are singled out in Section 7.
Can there be 2 violations, as your brother argues, in that you failed to have the sworn statement, but it also lapsed 30 days to make it a 6E violation?
No.
And why not?
The reason is, in my view, this. Section 6 is about forfeiting the security deposit. If you accept the argument that 6B triggers 6E, you must necessarily then say that every forfeiture of every other subparagraph in Section 6 constitutes a forfeiture, and you must also say that the time limit then for refunding the money is what 6E says, 30 days after the termination of the tenancy. I would submit that that is bad for Massachusetts tenants. Because consider, for example, a 6A violation, failure to deposit in an escrow account. That happens early on, right after the landlord takes the security deposit. So it's early in the landlord-tenant relationship. The violation occurs when he fails to deposit. The forfeiture occurs when he fails to deposit. But if you accept the argument of Mr. Phillips, he cannot obtain a refund of that money until 30 days after the termination of the tenancy, because there is no intelligent reason to distinguish the first 4 subparagraphs and the violation of E. The only thing about E is that it has a time frame for the performance of the act specified there, the return of the amount the tenant is entitled to.
Let's say there is a violation of A. Are you saying differently that when could the tenant get the security deposit back on your view?
If you accept the argument being made by the appellant,
No, I want to know what you say.
I believe that the requirement for the other forfeitures in 6, although not specified in the statute, has to be upon demand.
Okay. So here, there was a demand.
There was never a demand for a refund of the security deposit.
Pay me the security deposit.
The demand always was, pay me 3 times the security deposit.
Well, actually, the demand was, the first letter was pay me the security deposit.
Before they even received this statement, yes.
Well, I moved out, I want my deposit back.
Yes.
So that's not a demand for security deposit?
Sure, but we hadn't committed a violation at
But
that
you
point.
did commit a violation.
Subsequently.
Okay, but you did commit a violation.
Yes.
And that violation was one that results in forfeiture.
30 days after,
No, it results in
Occupancy
forfeiture.
ends.
It does result in forfeiture.
yes,
Okay, and it has not been paid.
yes.
All right, and you make the tenant chase the deposit that is plainly forfeited.
Have to disagree there for a very simple reason. We had until June 20th to correct the mistake in the statement.
And did you?
No, we didn't know of it.
Well, it doesn't matter, right? This is a strict liability sort of statute, isn't it?
I'm not so sure I'm prepared to concede that with respect to 6B and C. But the facts are, we weren't aware of the dropping of the sworn to legend until after the 30 days
All right,
expired.
but you became aware of it,
Yes,
and you still didn't refund it.
yes,
That's right, you did not.
correct.
Yeah, even though the statute makes clear that this kind of mistake, whether intentional or unintentional or whatever, still results in forfeiture.
Yes, that's true.
Right.
However, may I add Once we became aware of it and the obligation to refund existed, there was no chance to refund because the only request from the tenant was for 3 times the security
Was
deposit.
there a tender of the $750 deposit?
No,
No. At no point,
at no point.
right?
Well, assuming you don't want to hear about settlement discussions.
So
No.
why couldn't you give the $750 back?
The-
Why say, well, they're asking for 3 times, therefore we're not going to give anything? That doesn't make any sense.
A fair question, and I believe the real question is, why didn't you tender the $750
Yeah.
sometime between June 23rd of 2013 and August 6th of 2013 when the complaint was filed, or perhaps even later? The answer to that question is not as simple as I'm about to make it sound, I suspect. First, futility. Mr. Phillips, through his father, made it clear the only thing that would satisfy him was 3 times.
Okay, but you're the lawyer, so you know that.
I wish we were a good enough organization. The lawyers were always involved in these kinds of
You
things.
know that, okay, they say they're not going to take it, but to preserve my client's rights, I want to tender the $750, and it's on them whether they refuse it or not. So
And-
you can't really hide behind that.
Well, from a legal perspective, I can't. From a practical perspective, what you're basically asking is, why weren't lawyers involved in this case before the complaint came along?
Or at any point.
Well, certainly we were once the complaint came
No,
along.
and there was no tender after that either.
There was no tender after that because, second reason besides futility, the class action nature of the complaint, in particular, the fact that the general class in this case was alleged not to be 1,762 people, but everyone who in the last preceding 4 years had received any itemized statement involving any damages.
Now, has there been a class certified in this case?
No.
All right, so this is a case, I don't understand what this class issue has to do with anything.
I thought, perhaps inadequately, I was responding to the question, why didn't you tender after you saw the complaint?
Well, as to this particular tenant.
Why didn't we tender to this particular tenant after we saw the complaint, besides the reason he never indicated that any amount other than 3 times would satisfy him? The reason that we didn't tender after is because, number one, we thought it would be deemed a pickoff of a class representative and rejected on that basis, or an attempted pickoff. The third reason is, under the teaching of Taylor 1, once 30 days has elapsed after the end of the tenancy, it doesn't matter whether you tender or not. You are just as much a violator as if you tendered. And certainly by that time, as a matter of fact, before we even heard from Mr. Phillips, the 30 days had elapsed.
If I can go back to Section B, 6B. Here, of course, we had the issue of payments and penalties of perjury, and I guess there were other arguable issues never reached as to the appropriateness of the deductions that were made. But what if a landlord were to say, you know, I'm just not going to give the itemized list. I don't want to give it. It gives me a lot more flexibility to simply say, I'm going to give you back only $100 of your security deposit because that's all that you're due. In your situation, what's the remedy of the tenant?
I assume, from your question, the money is being retained for damage to the unit,
We don't
as
know.
opposed
We
to
don't-
for rent or
We
taxes.
don't know. The landlord decides it's a lot more, gives me a lot more flexibility if I don't have to itemize, so I'm not going to do it. I'm just going to basically declare, here's the balance of your security deposit. We have no idea as to its appropriateness. remedy of the tenant.
Okay. First of all, a rather important point, I think, to point out. The security deposit statute does not require a landlord to submit anything to a tenant if the security deposit is being used solely to offset rent. That's in Section 4. The only itemized statement that is required is for damages to a unit.
Okay? But
Okay.
In my scenario, there is no itemization of anything
Okay.
Or explanation, presumably.
or explanation. It's
Okay.
just, here's a check, or you get nothing back. Let's make it even cleaner. I know that you gave me a security deposit, you're entitled to nothing.
One would hope the tenant would make a demand for return of the security deposit. If the amount that had been withheld was withheld for damages to the unit, and the 30 days had expired, and the landlord, as in your hypothetical, Chief Justice, refused to return it, make a demand under 93A and get your treble damages because that landlord has knowingly withheld that money. And
you're
it's a
saying the only-
violation of
The only remedy is
93A.
for 93A? You're saying there's no remedy under Section 7?
For failure to tender a itemized statement?
Yeah.
No.
So they can just blow it off entirely, and the best the tenant can do is either get his or her money back pursuant to the forfeiture, or file a 93A. That's how you believe that's what you believe the legislature wanted to happen.
I believe the legislature wanted to happen if the tenant made a demand and it was clear that the landlord had screwed up, that the landlord would give the money back. And by doing so, would shift the leverage. Once the money is given back, the tenant has no reason to file a lawsuit. It is then up to the landlord to try to make the decision whether or not to sue for those damages. The whole point, in my view, of Section 6 is to shift the leverage of who has to make the decision to sue.
Okay, so in your world, the legislature essentially, in your world, if the landlord decides to ignore that obligation, realistically, in the absence of a separate 93A action, the best the tenant can do is get his or her money back for the full security deposit. That's all that they can get. They can get only that to which they are entitled, nothing more.
Section 7 was written to exclude 6B, yes.
Okay, and if they basically say, this seems wrong, I need to retain counsel, they must pay, they can receive no recompense for the retention of an attorney unless they file 93A.
93, in my view, a tenant's request for a refund under those circumstances would result in a refund automatically
Or
every
not.
time.
Or not, so.
Unless the landlord was a complete idiot, yes.
Well, I mean, so the tenant basically receives no itemized list, just receives a letter to say, we've determined that nothing more is due. Let's assume the tenant then writes a letter to say, no, I think something is due, does not get a response. The best they're gonna get is file suit and get the money back unless they file 93A.
If all the landlord failed to do was supply a legend, but otherwise gave an itemized statement that was signed, and the tenant, in those circumstances, said, I don't have any problem with what you've said. I don't have any problem with what is in your letter. I don't have any problem with the fact that you signed it. But you forgot to put sworn to.
Okay, that's not my, but.
I
you're-
understand,
You're asking us to not be limited to the pains and penalties of perjury. You're saying any violation of Section 2, including the failure to give any itemized statement, has the same consequence, which is that there's no entitlement to attorney's fees or treble damages unless you file a 93A action.
No, not exactly.
Okay, well,
I
then
believe.
explain to me how.
I believe if you fail to give an itemized statement, you better have a tender of the deposit that is only dealing with rent, et cetera. Because under those circumstances, If you just are going to deduct rent, you're okay.
Let's assume, in my hypo, the landlord is doing it for God knows what reason. The landlord may just, we don't know what reason the landlord's doing. All we know is that I get nothing back, and I get a letter that says I get nothing back, and I get no explanation of it. Is it, I mean.
Make your demand.
Am I correct that in your interpretation, my only remedy apart from 93A in a separate action would be I get to go to court and I get my money back, period?
I don't mean to be argumentative, and I don't mean to resist your hypothetical. At the end of the day, it kind of depends on what the reason for withholding this security deposit was.
But it seems to me that you're having trouble accepting that consequence, and maybe the reason you have trouble accepting that consequence is because it appears to be fundamentally unfair to the tenant.
Of course it's unfair to the tenant, yes.
And so in your view, the legislature intended a result which potentially could be fundamentally unfair to a tenant because it would permit a landlord to essentially blow off his or her obligation to give any itemized statement, and the only consequence would be the best you can get is your money back.
The problem I'm having with the hypothetical is, to me, the failure to furnish an itemized statement is a distinct obligation from the obligation to refund the money, which is in E. You must refund the money that's owed. It is distinct and it is clear. And if you don't refund the money that's owed under E, then you suffer the consequences of paragraph 7. B, on the other hand, is the failure to furnish a statement. And the hypothetical, with just a letter, et cetera, doesn't really address the failure to refund the money under E in a timely way versus the failure to furnish the statement in a timely way. And to me, the two are distinctly different obligations.
Okay, thank you.
Thank you.